Okay, welcome everyone. Warm thanks for you to join us in this webinar on behalf of SEPS. I would like to first introduce myself. I'm Sergio Carrera. I'm Senior Research Fellow at SEPS, following justice and home affairs and rule of law matters, and I'm delighted to be chairing today's webinar and to have this moment of sharing with all of you a very central and politically relevant topic: the relevance of safeguarding the rule of law for the future of Europe. And of course, we are witnessing a lot of measures adopted by several EU governments across the Union on states of emergency, derogating constitutional checks and balances and having a huge impact on people's liberties and rights. And in the name of the pandemic and COVID-19. And today we wanted to have this debate about what can the EU do to make sure that those principles which underpin European cooperation and European integration are indeed safeguarded across the Union. And SEPS, we are keeping quite busy actually during this time, not only through this unique opportunity to have a webinar via Zoom, but also through research. We just published a new paper on Schengen, the impact of COVID-19 policies on Schengen and EU free movement. And also we are preparing a new paper together with Petra, myself and Petra on the situation in Hungary at the moment, with the new laws and the impacts of pandemic politics on the rule of law and fundamental rights. So just briefly, rules of procedure for today's webinar. We will have 1 hour and 15 minutes ahead of us, and we will start with introductory remarks by Carrera, SEPS CEO, who will then introduce our keynote speech. We are delighted to welcome Commissioner Didier Reynders with us. And then after his keynote, we will have two discussants, Katarina Barley, who is Vice President of the European Parliament. We are also very happy to have the Parliament's view and work represented in today's meeting. And then a colleague and a long friend of SEPS, Petra, professor at the Central European University. So after Commissioner Reynders' keynote speech, we will open the Q&A option that you all have in your Zoom window. Please be aware and please make sure that you write only one question very clearly. We are very happy to have so many attendees, more than 300 attendees today. So in terms of feasibility of how to handle the Q&A, please write it very clearly, the question, identify yourself and your organization. SEPS team will be filtering those questions, and I will be bringing those selected to the panelists for the sake of having a consistent debate. So this event is streamlined. So at the moment in YouTube, and it will be posted in YouTube. And please follow us in SEPS Twitter while this webinar is being held. So from my side, I would like to leave it here for the moment. I would like to give the floor to Carrera now. Carol.
Okay, thank you, Sergio, and good afternoon, all of you, and good afternoon, especially to Commissioner Reynders, but also to Katarina, Barley, and Petra, let's say, for joining this seminar this afternoon. I think, let's say, we're very privileged that we have the Commissioner Reynders to participate in this session. It is a crucial issue, so we're not only speaking in times of COVID-19 about issues related to medicines, to healthcare, to personal security. We're also now speaking about issues related to rule of law, because we have seen some issues which have happened over the last days and weeks in Europe, let's say, which can raise concern for the rule of law in Europe. And as I said, let's say, I'm really very happy that Commissioner Reynders can join us today. I know that Commissioner Reynders has a long experience as principally a minister of Belgium, Minister of Foreign Affairs, before that Minister of Finance in Belgium. But I would indicate, let's say, that as a Minister of Foreign Affairs of Belgium, he's been working, representing Belgium in the Foreign Affairs Council and insisting since a long time with a group of countries on issues related to rule of law. I think it's also from that perspective, let's say, I know as a commissioner in charge that he has, I mean, the personal experience, let's say, in dealing with these matters. And that's why I'm really very happy, let's say, that you can join us this afternoon and speak about this issue. I can also say that Commissioner Reynders spoke about this theme with us 2 years ago at the SEPS Ideas Lab, where he hosted a session, moderated the session on the issue, specifically focused on the rule of law, but also the colleagues from SEPS dealing with the justice and home affairs matters, where we had a long and very interesting exchange of views. So with this, I want to pass the floor to Commissioner Reynders, and I would like to thank him, as I said, very much for joining us this afternoon, and I hope, let's say, we'll have an interesting discussion. Commissioner Reynders. Unmute.
Yes, well, it's done.
Yeah.
Thank you very much for your kind words of introduction, and thanks for the center, because it's a good idea to organize such an important discussion about safeguarding the rule of law for the future of Europe. And it's not a new debate. I've started through in the beginning of 2016 to discuss that in the General Affairs Council, to try to peer review on the rule of law. But as recalled last week by Commission President von der Leyen, the European Union is founded on the values of freedom, democracy, the rule of law, and respect for human rights. And we must uphold and defend them, even in these challenging times. In fact, the current health crisis renders even clearer the importance of upholding our fundamental values. Over the past weeks, several EU governments took emergency measures to address the health crisis caused by the outbreak of the coronavirus. We are living in extraordinary times, and governments, in principle, need to have the necessary tools to act rapidly and effectively to protect the public health of our citizens. The Commission fully supports member states in their fight against coronavirus. At the same time, we must respond to the crisis in the European way, in full respect of fundamental rights. And it's important to repeat that. It was a long discussion some months ago about the European way of life, that is the Article 2 of the treaty, the European way of life. And so we need to pay attention to that also in such a crisis. And democracy cannot work without free and independent media. Respect for freedom of expression and legal certainty are essential in these uncertain times. Now, it is more important than ever that journalists are able to do their job freely and precisely, so as to counter disinformation and to ensure that our citizens have access to crucial information. Member States' emergency measures need to be taken with full respect to the rule of law and fundamental rights, and must be limited to what is necessary and strictly proportionate. They must not last indefinitely. Government must also ensure that such measures are subject to regular scrutiny. For these reasons, the Commission has decided on my proposal 2 weeks ago to monitor very closely the impact of the anti-COVID-19 measures on fundamental rights and values. We are looking at the situation in all member states. This is indispensable for ensuring a fair and equal treatment between member states. We also need to look objectively at the overall system of checks and balances, which is specific to each member state, and at the concrete impact of these emergency measures on the ground. This will enable us to identify the appropriate response. Over the current emergency, we should not lose sight of the need to uphold and strengthen the rule of law more generally, to which the Commission remains strongly committed. In particular, despite the current challenges, our work on the preparation of the annual rule of law report is progressing well. Our objective remains to adopt the report by September, subject to circumstances permitting this, but we try to maintain the same objective. As a preventive instrument, this report will allow the Commission to deepen its monitoring of the rule of law situation in all member states again, identify risk, develop possible solutions, and target support early on. The added value of the report is that it should serve to inform the dialogue with and within the European Parliament and the Council, as well as the discussions at national level. Of course, this will not prevent the Commission from launching reactive action, such as infringement procedures, if necessary, We have again do that at the beginning of this year against some disciplinary proceedings in Poland that you have maybe seen that we have had a discussion and a decision today from the Court of Justice asking to Poland to suspend all the proceedings in the disciplinary field on the request of the Commission. The report will cover significant developments in member states, both positive and negative, within 4 areas: justice systems, and in particular, their independence, quality, and efficiency, the anti-corruption framework, certain issues related to media pluralism, and other institutional issues related to checks and balances. In addition to the input from member states, the Commission will rely on a diversity of relevant sources, including contributions from the Council of Europe and stakeholders. In particular, stakeholders have the possibility to contribute through a targeted consultation, which was opened on the Commission's website on the 24th March. I invite all interested stakeholders to contribute, including, of course, the Center for European Policy Studies, if you want to do so. In addition to the work on the rule of law, the Commission is committed to promote awareness among the general public on the importance of the rule of law. In the long term, this is best guaranteed against challenges to our fundamental values. The Commission has therefore committed to make full use of funding possibilities to empower stakeholders, including civil society, to promote the rule of law. Academia, think tanks, civil society organizations, and other stakeholders have an essential role to play here, as you can help communicate to the public the importance of the rule of law in our everyday lives. As Justice Commissioner, I'm interested in your ideas on this crucial topic. We need more such initiatives which reach the hearts and minds of our citizens across the Union. Finally, the Commission will not hesitate to use its rule of law toolbox where needed. This toolbox allows the Commission to address different challenges through a diversity of responses. In particular, the recent case law has shown that the Commission can, in certain situations where the independence of the justice system of a member state has come under threat, successfully bring infringement proceedings against a member state for violating the principle of effective judicial protection and the right to an effective remedy, as guaranteed by Article 19 of the Treaty on the European Union and Article 47 of the EU Charter of Fundamental Rights. The possibility to launch infringement proceedings to ensure judicial independence is a very important development in the EU, underlining the fundamental role of the Commission as guardian of the treaties. And the Commission has made use of this possibility in a number of infringement proceedings. Notably, the Commission has seized the Court of Justice at several occasions to protect judicial independence in Poland. On 24 June and 5 November 19, the Court of Justice held that Polish legislation concerning the lowering of the retirement age of Supreme Court judges and of ordinary court judges was in breach of EU law on judicial independence. Furthermore, on 10 October 19, the Commission decided to refer Poland to the Court of Justice regarding the new disciplinary regime for judges on the ground that it undermines judicial independence by not offering the safeguards to protect Polish judges from political control. On 19 January 20, the Commission decided, I said, to ask the Court of Justice to impose interim measures on Poland, ordering it to suspend the functioning of the disciplinary chamber of the Supreme Court. Hearing in that regard took place on the 9th of March, and today, I said, we have received a positive reaction from the court asking to suspend all the procedures in Poland. There is also the new Polish law on the judiciary, where the Commission will have to decide on the way forward based on its analysis. We must ensure the respect of EU law. At the same time, the Commission remains ready, of course, to continue constructive dialogue with the Polish authorities to solve the issues at hand. In addition, the Commission has made use of its legislative right of initiative by submitting a proposal for a regulation on the protection of the Union budget in the event of shortcomings in the rule of law in the member states. The reasoning is simple. in order to control the use of EU funds and to protect the financial interests of the European Union against corruption and fraud, we need in each member state independent justice systems, effective investigation and prosecution services, and an effective functioning of public authorities implementing the union budget. If these functions are underwritten by a generalized rule of law deficiency, the union would be empowered to suspend, reduce, or restrict access to EU funds in a proportionate manner. Of course, the Commission proposed that the Council take this decision by reverse qualified majority to don't have the same blockage that we have when we use unanimity or just the qualified majority. The proposal is currently being examined by the European Parliament and the Council of the European Union, and if adopted, could make an important contribution to the protection of the rule of law. I hope that this provides you with a good overview of what the Commission can do to safeguard the rule of law for the future of Europe. To conclude, let me reiterate that the current crisis reminds us all, in fact, of the importance to uphold on our fundamental values. As Justice Commissioner, I will be committed to take forward the Commission's action to address this challenge. I have made a report on the emergency measures in the two last college last week and this morning again. I must say that we have specific concern about some member states. I have expressed the view that about Hungary, we need to be very active in the monitoring of all the measures due to the fact that we don't see a real term to the state of danger decided by the authorities. And we have some concern about the new criminal law about the dissemination of false information. There's a risk for the freedom of press and freedom of expression. I want to say that we don't have elements to launch an infringement proceeding against one of another member state about the law. The laws decided to install the state of urgency or the state of danger, but we will monitor all the measures taken in application of those laws. And it will be very important to see if there are some things to do on it. And we have different possible proceedings to conclude, to go back again to the Court of Justice if there is enough element to introduce an infringement proceeding in one of another member states, to continue the discussion on the basis of Article 7 at the Council level, because we have two procedures about Poland and Hungary in the Article 7, and then, of course, to continue to discuss about the possibility to have a conditionality in the use of EU funds, like we have proposed from the Commission and is at the table of the Council. I want to add, but we have maybe some question on that, I don't want to elaborate, that I proposed also to start 2 weeks ago the same monitoring about the use of personal data in the fight against the crisis and in the fight against, and maybe in the way to exit of the crisis, because you know that there are some possibilities to use a lot of data. It's in full compliance with the GDPR, but we need to verify if it's sometimes in some kinds of apps, it's not against the GDPR due to the fact that there is no consent of the individuals to use their personal data. But we are at the beginning of the monitoring, and we see that there are many discussions in many member states about that, so we continue to monitor. But thanks again for such an opportunity. I will be very happy to listen to the comments from the other participants, and certainly also to try to answer to the questions. Thanks.
Thank you, Commissioner, for bringing to light the importance of the European way, as you put it. That Article 2 of the treaty is not an empty box, that it has very meaningful substance that you've taken us through: independence of courts, freedom of the press, civil society, academic freedoms, etc. And thank you for highlighting the role of the Commission and the importance also of the Court of Justice, which has been playing a very effective role in monitoring rule of law development. So thank you very much. I see that people are already posting a number of questions that I will be looking at while our discussants also contribute to this debate. I would like to give the floor to Katarina Barley. The European Parliament, we know, is working quite intensively on this subject, and there's been work on Hungary and Poland, and more generally, the establishment of a mechanism, a rule of law mechanism. We are looking forward to hearing from you, Katarina, about your views on this. Thank you.
Thank you very much for organizing this event, and especially thanks to Didier Reynders, to the commissioner. I really appreciate his work very much. We have to be critical towards the Commission. I am also, but I really want to say that here for once, that I really am happy that he is our commissioner at this moment. I would like to come back to the title, to the relevance of the rule of law, of the safeguard. Why is it so relevant? It's so relevant because it's the fundament for everything we are doing at the moment, for the existence of the European Union, actually, for all the actions we take. It's mutual trust, it's mutual recognition. It's, as Commissioner Reynders already said, the use of the financial means of the European Union has to be controlled, conform to the rule of law. Otherwise, we couldn't distribute financial means to the member states. If we guarantee the freedom of movement, we want our people, our citizens, to be protected in a similar way in every member state. So it is actually the fundament, and therefore it is everything else but an empty box. It's what lies underneath everything. And we couldn't have a better time to discuss this, because we have forces from inside the European Union, but also from outside, who want to weaken or even destroy the European Union. And I'm completely convinced that complying to the rule of law is actually the shield, the best shield that we have against all the attacks that we are facing. And as I have to say, especially for the attacks from the inside. Hungary and Poland have been mentioned. It's also now the new government in Slovenia that is very much supporting Orban's way. We really, and now looking at the emergency measures, I don't really want to add very much to what Commissioner Reynders said. The freedom of movement, the freedom of expression, the freedom, the data protection, all these issues are at stake. So at the moment, yes, we need a lot of measures to protect us from the virus, all of us, but we have to be very cautious of what governments do there, how much power they grab. It's not only these countries that are the usual suspicious, as I might put it. It's also it's also countries that are usually compliant with democratic rights that become kind of greedy when it gets to data. Even in my home country, we had to defend well, they were trying to grab health data, and fortunately the Parliament was able to reject that. So the Parliament has asked for more measures concerning the rule of law for a long time, and we've had a report in 2016 already, because at the moment we only have Article 7 and we have the European Court of Justice, who is really doing its work extremely well, we have to say. So we have seen the report of 2016 calling for this this annual rule of law monitoring, and we are having a report on this ourselves as the European Parliament. I'm the shadow rapporteur there. So we have examined very closely what the Commission has published there for now. I must say I would like to question why it's only those 4 areas that are being mentioned: the justice system, anti-corruption, media pluralism, and checks and balances, because we have a lot of other fields that are concerned, especially the rights of minorities. We have the freedom of science, education, culture. We have election procedures. I can't really see how they fit into these 4 points, and I don't really see why it has to be restricted to these 4 areas, although the point of checks and balances is one where one can certainly put a lot of topics into. But I would really like to ask this to the Commissioner. I'm very pleased that the Commission is not only looking at the problems, but that they also want to quote positive, good practices. This is something that we as a parliament would like to address also. In the parliament proposed to also involve independent experts. This is not foreseen, as far as I can see, in the proposal by the Commission. There are a lot of institutions that are being named, and I would like to ask if independent experts can be involved too. What the European Parliament also foresaw was an automatic reaction of the Commission if you have an infringement of the rule of law by one of the member states. There, I can't find anything in the proposal either. Then I was a bit puzzled that the contributions by the member states would only be made public if the member states agree to this. I don't think that they need this measure of protection. I think an official statement by the governments has to be public so that it can be questioned and discussed by the public. The last point, maybe what makes me a little pessimistic, I think we are really running out of time. We have waited far too long to react to Hungary. Then we had Poland, which blocked the Article 7 procedure system. Now we are seeing other well, authoritarian governments more and more. And then Commissioner Reynders mentioned it. If we then see that the Council does not accept the proposal that they need a 2/3 majority to reject the proposal by the Commission, but they want to have a 2/3 majority that confirms it. I really fear that this mechanism could be equally weak in the end, almost, as the Article 7 procedure. And I would really like to know how the Commissioner sees it, if this is something where the Council can be convinced that we need to be strong here. And of course, what we need in the end are financial measures to be taken. This is the only thing that really stops authoritarian regimes from carrying on. Now is really, I'm convinced that we're at the crossroad now, that if we don't manage to install a powerful mechanism, I want to stress that, to sanction violations of the rule of law in a vast term, including separation of powers, independence of justice and everything that goes with it. If we don't implement that now, it might be too late, and it might be the end of the European Union as we know it, which brings me back to the relevance of safeguards. And this is where I would like to end. Thank you.
Thank you, Katarina, for highlighting what some of the participants are also bringing in through their questions, the importance of enforcement and follow-up. To have a solid enforcement and follow-up, how to make sure indeed that the EU toolbox, rule of law toolbox, actually has an impact and can be meaningfully followed up and in a timely manner. You were also saying how important time is. Time is crucial in these situations to act in a timely manner and to take action at EU level. So thank you very much for that. Now, before coming back to the Commissioner for also continuing the conversation and some of the points that you've raised, I would like to give the floor to Petra Barley, who has contributed to SEP's work also for several years on this matter, and we look forward also to hearing her views on these topics. Please, Petra.
And to be able to comment on Commissioner Reynders' proposals and to listen to Vice President Barley. Extraordinary times call for extraordinary measures, and I very much agree with the Commissioner that coronavirus politics must not mean the dismantling of the founding values liberal democracies are supposed to be based on, such as the trinity of democracy, the rule of law, and fundamental rights. Democracy should be about conducting and enabling meaningful critical debates and for governments to justify their actions. This is only possible, however, if people have access to information and if effective scrutiny standards are upheld. In contrast, whenever people have little information, they become even more frightened and panicked and become ready to abandon rational decision-making and confer their most intimate liberties and rights to a father figure who is willing to protect them. Also, while presented as temporary, these measures during a crisis have the tendency to become prolonged again and again, way beyond the actual state of emergency. Now, my country of origin is Hungary, and indeed the Hungarian government took lead in abusing the pandemics and has got under the spotlight after passing the so-called Enabling Act, declaring a state of danger that has already been referenced several times by the Commissioner. Let us, however, recall that there are very different challenges that states based on the rule of law, liberal democracies based on the rule of law respecting fundamental rights are facing, and those where constitutional capture has already happened. Let us recall also that Hungarian democracy has been in decline for at least a decade. By today, all relevant international and European reviews and indices show that it ceased to be a liberal democracy based on the rule of law. So whenever doing the pandemic scrutiny, I would like to emphasize that it's not the pandemics or the epidemics that create autocracies, they rather just help the system show its real face or true colors. Now, the new controversial law on protecting against the coronavirus in Hungary, even though it doesn't suspend entirely parliament, it introduces a rule by an executive decree without a sunset clause that is for an indefinite period of time. But this is not the first time that the Hungarian government jumps on a crisis and tries to abuse it. A state of emergency has already been declared in 2015 due to the mass migration, and this has been prolonged then again and again in the name of the fight against illegal migration up until today, even though asylum seekers, as we know, cannot enter Hungary anymore, and indeed the average Hungarian has never met a single refugee. So now we are fighting another invisible enemy. This time, this is the virus. Now, the Hungarian government had everything that was there, that was needed in order to fight the pandemic, but for some reason it wanted to more. In the Enabling Act, as Commissioner Reynders rightly said, it introduced amendments to the criminal code on spreading a falsehood or distorted truth in relation to the epidemic. And it has been severely criticized for being able to be abused, for going after the remaining independent journalists in an environment, in a media landscape that is already very much distorted. The only safeguard remains to be the Hungarian Constitutional Court. However, a contextual analysis is needed, whether you are scrutinizing pandemic legislation or just doing a rule of law health check for the member states. The Hungarian Constitutional Court, or any constitutional court for that matter, would be a theoretical check on governmental powers. However, if you look in a contextual analysis of the Hungarian setting, you will know that in order to be able to turn to the Hungarian Constitutional Court, most cases need to go through ordinary courts, which are limited in operation right now, and therefore cannot even get to the Hungarian Constitutional Court. Even if they could, the Hungarian Constitutional Court has been an ally and a rubber stamper for all government policies in the past couple of years. So this is not a meaningful check. The novelty of the enabling law, even though Hungary abandoned the path of rule of law a long time ago, is abandoning now even the semblance of a democracy. If the government's objectives were honestly the fight against the pandemic, why was there a need to do away with parliament, which is anyway on the government side? Fidesz had all the tools and power available to fight the virus, even before adopting the Enabling Act. But we look at the government's first steps, and this is what Commissioner Reynders also emphasized. Not just look at the black letter law, but actually look at the implementation of it. One of the first steps in the Hungarian context were doing away with transgender rights, classifying business information in relation to China, giving real estate to allies of leading politicians. So our suspicion that there might be some hidden objectives behind the adoption of this legislation may be justified. One of the objectives seems to be an even greater paragraph. Another is creating a scapegoat in case the fight against COVID-19 is unsuccessful, which is highly likely to happen because of the very poor state of the Hungarian healthcare system. But another likely objective is testing the system by giving up even the pretense of being a democratic state. This move is important from the viewpoint of building networks with other wannabe authoritarians to see how the EU reacts, or whether it reacts at all, or whether one can get away with building an autocracy with impunity. Now, responses to backsliding in various member states, including my own, came too late, were too little, or very political. In the face of the pandemic's politics, some politicians in their initial statements just emphasize the importance of the rule of law without, however, pointing Hungary. Also, a group of 13 concerned member states stressed the importance of values, again without mentioning Hungary expressly. In a very sarcastic move, Hungary then joined these signatories of member states, thereby ridiculing the whole action and rendering it meaningless. It really shows the deep cynicism and how fake the whole system is. Now, there is often an argument saying that it's not the right moment to pick a fight at the time of a pandemic. However, the Venice Commission clearly concluded that past historical experiences have showed how the gravest human rights violations did happen during declared states of emergency. Even though the EU doesn't act very forcefully, it is not a paper tiger. As Commissioner Reynders mentioned, the EU rule of law toolkit is available for the various institutions. Now, in my view, the main problem is that most of the institutions continue to believe in the force of a political dialogue and prefer this over the techniques of enforcement of values enshrined in Article 2 of the Treaty on the European Union. Instead, all EU institutions shall recognize that the discursive approach might work well with those member states that adhere to the rules of the game. However, when it comes to a systemic rule of law backsliding with governments consciously and instrumentally engaging in dismantling constitutional checks and balances, the effectiveness of any reaction hinges on the response, or as you say, on the enforcement prong. Now, let me mention three such tools. One of the most promising amalgam against rule of law backsliding seems to be infringement proceeding, but a special type of it that we call rule of law infringement proceeding in the literature. These are infringement procedures that are accelerated and used in conjunction with interim measures. It has been used successfully in relation to Poland. Once the negotiating phase with the Commission proves to be fruitless, the Commission should without delay turn to the Court of Justice in Luxembourg, which again shall prioritize and accelerate the procedure. The diagnosis, and this is my second point, or analysis backing up EU institutions' rule of law assessment must be independent and scientifically robust. The Commission's attempts have already been highlighted, but it's not just the Commission, but also the Council and the European Parliament, which have been fine-tuning their own mechanisms in compliance with the rule of law. The emerging picture as a consequence is one of competing tools, and each and every institution, EU institutional actor, claims to know how to go on best about Article 2 risks and threats. Preferably, there should be an agreement on one single mechanism. And my third point is, once this becomes operational, the burden of proof should shift to all national governments to justify and provide evidence of the goals and intended effects of their policies in light of Article 2. Governments should also refrain from distorting or withholding information, especially in a pandemic, but in general as well. And the EU could proactively contribute to whistleblowers' protection and putting a halt to the abuse of litigation against journalists by adopting anti-SLAPP, anti-strategic lawsuit against public participation legislation. Commissioner also mentioned the power of the purse. Let me here just remind you of the Commission's 2014 guidance on ensuring the respect for the Charter of Fundamental Rights and judicial independence when it comes to the implementation of European structural and investment funds. And the Commission should at least require the existence of independent judiciary capable of examining complaints concerning the distribution of funds whenever money is allocated. So in sum, I conclude by saying that the Union has to realize that it is existential for it to react firmly. The survival of the Union and its co-functioning principles, such as primacy, direct effect, loyalty or mutual trust, and mutual recognition, are all at stake. It is impossible to uphold integration as we know it without taking the rule of law seriously. Thank you very much.
Thank you, Petra, for bringing to light key lessons learned from the tale with the Hungarian government backsliding on the rule of law and the EU responses there, and how important it is also, coming back to Katarina's point, enforcement, and realizing that there are times where political dialogue, especially in cases, specific cases where we have witnessing constitutional capture, cannot be conducive to effective responses. And this is indeed what we are, if anything, you were saying the true colors of this Hungarian government are becoming more obvious in the name of the pandemic. And you were also highlighting the potential role of rule of law infringement proceedings, bundling different elements together and really putting it under the proper, clear framework, that this is a rule of law issue. Now, so thank you very much, Petra. I would like to offer the possibility to Commissioner Reynders to come back to some of the points that the two discussants have mentioned, particularly Ms. Barley was referring to a couple of elements where she was seeking clarification, particularly first regarding the focus of the Commission's reporting, not being limited to the aspects that were highlighted, but also including others like democracy, minority protection, and she was raising the question why to restrict that reporting to other areas. And also she was mentioning something that Petra highlighted too, the crucial role of having a scientifically robust independent assessment in this kind of reviewing by the Commission, and wondering how the Commission sees specifically the role of independent scholars and having an independent assessment in such a politicized environment. Commissioner.
No, thank you for such an opportunity. I'm very pleased to see that there are so many requests to have a real attention, to pay real attention to the rule of law, because I must say that I was Minister of Finance during 12 years in Belgium, before to become to be Minister of Foreign Affairs during 8 years. And since 20 years, I have seen many discussions about the budget, about the structural reforms, about the Stability and Growth Pact, and with some proposals coming from the Commission. And then since some years, we have the European semester and a lot of actions, in fact, to verify the real convergence in the academic field and to verify that it's possible to fulfill the criteria of the Maastricht Treaty. About the values, about the Copenhagen Treaty, about the political criteria, it's not the same. And I must confess that my first intervention about the situation in Hungary was in January the Council as Minister of European Affairs and Foreign Affairs to speak about some new change in the constitution and the law in Hungary. And at that time, 2012, 2013, the reaction was, it's not a question for the Council. It's a discussion just for the Commission, but not for the Council. And it's true that in 2016, I want to repeat that, we have seen first discussion in the Parliament about a possible mechanism to verify the situation about the rule of law. And I've started at that time with some colleagues, my colleague from Germany at that time, to discuss about a possible peer review at the Council level. And now, I must say that for the first time, we have 2 Article 7 procedure on the table. We will have, at the end of the year, and I said in September, the first annual report on the rule of law, the basis of the communication of the Commission last July. And of course, we are confronted with the first crisis with so many emergency measures in many member states. So it's possible to think that we will have a perfect system in some months, but after so many years, now we start. And I want to insist on it. It's very important to start. And it's the reason why my first answer is about the scope of the annual report. I've said that in the Parliament, in the Council, and of course in the Commission. We were working, like I've said, I don't want to repeat, with 4 areas. But there are other mechanisms. We have also a report about the Charter of Fundamental Rights. And when we discuss about the minorities, when we discuss about other kind of issues, it's more in line with the Charter. But we will publish also a report on the Charter of Fundamental Rights. This year we change the strategy on it, and we have the first report next year. And the same about democracy. We will have an action plan on democracy and a real debate on it. So I'm fully aware that it will be nice, if it's possible at the Council level, but certainly in the Parliament, to discuss all together the different reports. But about the rule of law, we try to start. It's a first report. It's an annual one. So we'll have maybe the possibility to move to other issues if it's needed in the next years. But I must say that it's a huge, huge activity for all the services to try to cover the 4 fields that I have mentioned. So independence of the judiciary, quality and efficiency, of course, also, because it's not enough to have an independent judge. It's also better to have a qualified one, and not only independent, but the fight against corruption, media pluralism, and check and balances. But again, we will discuss on other issues in other kind of reports, and it's possible to organize a global debate. Why is it a report from the Commission? But the Commission is guardian of the treaty. And so we are working with many experts, many independent bodies. But I received sometimes a question from the Parliament, why not to give the assessment to some scientifics or to some scientists or to some experts independent from the Commission. The Commission is the guardian of the treaty. And so we need to work with all the stakeholders, and we are doing that. Not only, I will say some words on it, with the member states, but with the Council of Europe, the Venice Commission, the Greco, more in charge of the fight against corruption. But I've said we have also launched a consultation, and it's possible for all the NGOs, for all the think tanks, for all the academics to take part in the consultation. And of course, to take part in the debate after that. But it will be a report of the Commission on the table of the Commission in September, like in other fields. And then we will engage with the Council, with the Open Parliament, and with all the stakeholders about our first report. I'm sure that we will receive a lot of criticism about the report, but it will be the first one. Then, why is it so important to organize such a discussion, maybe with a very large public? It's sure that we want to receive contributions, I said, from many stakeholders. Of course, we are working with very traditional one in the field of the Commission services, like the Fundamental Rights Agency in Vienna, FRA, or I said the Council of Europe, but we will try to work with all the participants who want to take a part in this process. Why is it possible for the member states to maintain their contribution confidential? It's true that it's better to have a transparent system in all, but we ask just to the member states to send some remarks about the description of the different situations in the member state, in one member state. So we will describe the situation about the independence of judiciary, and it's possible, of course, for the member states to say what are thinking about the description of such a situation. In fact, in all the chapters, we will explain what are the rules, because we are speaking about the rule of law, what are the standards, European treaties, case laws from the European Court of Justice, case laws for the European Court for Human Rights, that's the basis, then the description of the system, and then risk-based analysis, and then recommendation. It's just on the description that we are discussing with the member state. And I must say that if we want to receive many comments from the member state, it's maybe better to let the choice to the member state, to make their comments public or not. But at the end, again, it should be a report from the Commission and not with publication of all the different contributions. It will be a real report from the Commission. And about the conditionality, because it was the discussion, of course, it's true. Katarina and Petra said we need to go, Katarina said, to a powerful mechanism. It's the discussion, but we don't have for the moment. What are the tools in the toolbox? The most important tool for the moment in the hands of the Commission is to go to the court, to introduce infringement proceedings. That's the main tool that we have, and efficient. We have seen today about the disciplinary procedures in Poland. After the introduction of the request for interim measures, we received a concrete decision from the court today, and the court asked to Poland to suspend all the different procedures. And we have had the same process about, I said, other requests to the court about Poland, also about Hungary. But Article 7, it's a procedure to have a real political pressure, but at the end, it's very difficult for the Council to reach the qualified majority and the unanimity in the different steps of the process. And the conditionality, we start. Of course, I prefer, I said, to have a real powerful instrument with a reverse qualified majority and not with the actual system of majority. But it's in the end of the Council. So maybe with the actual crisis and the difficulties that we have with some emergent measures, it's very important to try to convince the member of the Council that if we want to organize a solidarity during such a crisis among all the member states, everybody must be solidary, everybody must be responsible, but also responsible to protect the rule of law and the fundamental values. And that's the same reflection that I tried to explain about the budget from the European Union. But if we organize more capacity for the Commission and for the European Union to act on the budgetary side, you know that there are huge discussions for the moment in the different institutions about that. But if it's possible to receive more capacity to act, of course, I fully understand that for many actors, it will be important to be sure that we are acting with solidarity in all the member states, respecting the rule of law. That's very important. So it's the reason why I tried that we need to go back to that. And then a last point, maybe, Petra, it's true that it's sometimes strange to see that for the first time, we have received in the Commission the support of many member states, and at the end, all the member states, I said in the Justice Council last Monday, it was also in the conclusion of the presidency, it was an informal meeting, to say we support the monitoring of the Commission. It's the first time that some member states said that it's possible to support the work of the Commission about such a monitoring. So this is good news. Of course, it's strange that it was without any mentioning of one member state, but I've mentioned during the Justice Council different member states again today. And so I'm sure that it's better to try to have it's my last word as answer, to have an interinstitutional action from the Parliament, from the Council and from the Commission to push pressure to install a real culture of the rule of law, a real debate. To be concrete, I see a beautiful series of books, Petra, on the picture that we have seen of you, but my intention is not to have a new annual report just to put in the library. It's an annual report just to open the floor for a debate at the national level. And you're right, we need to try to do that with the national parliaments, not only the Council and the European Parliament, but also with the civil society. And it will be a challenge. So I'm sure that we will receive many support to do that, but we need to go to all the member states and to discuss the annual report to be sure that it's possible to try to attract the civil society in a real debate on the rule of law in all the member states, and not just a debate in Brussels, if I may, because I'm coming from Brussels.
Thank you very much. I'm following up on this point, last point you mentioned. If I may take this opportunity, of course, the situation is one where I think Petra was mentioning that people are afraid, and sometimes in this context of panic and fear, many people may, at a first instance, sacrifice in a very easy way some of these liberties and so on, and see also the rule of law as something very technical. something very technical, like what, without how can, how can we engage citizens and individuals to critically be still alert on the importance or the impact that these technical matters have on their lives?
It's true that we need to go to the citizen to try to explain. The reason why we want to organize a real debate at the national level and not to let that just in the hands of the European institutions, the three, to go to the ground and to explain what. Just to give an example, today we receive a positive decision, in my mind, from the Court of Justice about the disciplinary proceedings in Poland. But of course, there are disciplinary proceedings against judges. It's not so evident to explain to the citizens that they are concerned by disciplinary proceedings against judges. They have other problems, and they are maybe thinking that it's a problem of the judge to be confronted with that. But if you explain that in your daily life, if you have one problem and you need to go to justice, of course, it's better for you to have an independent judge, and I said also a qualified one. So we need to work on the training of the judge, of course, but we need to protect the independence of the judiciary, to be sure that it's a protection of all the freedoms for the people. And that is possible to explain. The same about the media pluralism. We have the crisis for the moment. If you don't have different voices, it's quite difficult to be sure that you receive a correct information. It's quite difficult to have correct information about such a crisis, but you need to have a diversity in the possibility for the media to express different views and different kind of information collected through different channels. And that is very important to try to go to the ground. And it's the reason why I repeat, we have the opportunity to do a lot of things, to go to the court, to discuss on Article 7, to organize a conditionality on the budget. But at the end, the goal is not to introduce an infringement proceeding, it's to push pressure to have a real debate at the national level. If I may, some weeks ago, we have had many discussions about Malta due to the murder of one journalist. And the European Union provides some tools to the Maltese authorities to organize investigation. I'm thinking about Europol. Europol was playing an important role in the investigations. But we have seen also a real debate in the society in Malta about the independence of judiciary, about different kinds of issues relating to the rule of law. I'm not saying that the world will be perfect in Malta in some months, but we have now real discussions about real reforms with the Minister of Justice, about the justice system, about different kind of situation in Malta due to the crisis there for a specific situation in the country. And without such a capacity to open the door for a debate at the national level with the civil society, with the population, it will be difficult. So you're right. And if it's possible for many think tanks and many academics and others to try to organize the way to explain better to the citizens what that means, it's better also, because the rule of law is true. It seems to be a theoretical discussion about specialists, and it's not the case. It's a real protection for all the freedoms that we have in the European Union. And again, the European way of life, I have said during the debate about that some months ago, is just the Article 2. It's the capacity to have an organization of the Union with a full respect for the individual freedoms, for democracy, for the rule of law, for fundamental rights, in fact. And that's impossible to have without the rule of law. That means an organization on the basis of the law, and without an independent judiciary capable to verify that your rights are protected in line with the law. But it's true that we need to explain maybe through some examples what the reality is, because again, the independence of the judiciary seems to be far from the daily life concern of the citizens, but we received now, I don't want to mention which one, but we received some requests from companies explaining that it becomes to be difficult to invest in one country if you don't have the certainty that it's possible to go to independent justice.
Thank you, Commissioner. Several participants are raising a very specific question, which is what can be done when, for instance, situations of government in Poland and Hungary will not comply with even court rulings. And
but to be concrete, till now we are not confronted with such a situation. So I don't want to discuss about what if, because I prefer to say that it's an obligation for all the member states to comply. And I'm sure that we will see that it's possible to receive a real compliance from the member states. We have today, I said, a decision from the court about the disciplinary procedure in Poland. And the court asked to Poland to refer to the Commission to explain what it's done to comply with the decision of the court. And if you look to the last decision of the court, it was possible to see a positive implementation application in the member states. So I prefer to say that it's an obligation and to repeat it and to be quite confident that in the last resort, the member states are engaged to organize good compliance.
Thank you. Katarina.
May I add? Yes, may I add something there? I mean, the European Court of Justice is a very powerful institution, and we have seen several judgments where they also said if a country does not comply to the rulings, then they will face financial punishment. And that is something that the European Court of Justice can do by itself, and it has done in the past.
Thank you. Katarina, there are also some questions for you from the participants, also following up on comments expressed by Didier before on the role of the European Parliament. Petra was mentioning before the existence of different mechanisms. So we are seeing the Commission developing its own reporting. The Council also has their own reporting and peer-to-peer review. What does the Parliament have in terms of, or what is the Parliament thinking of in terms of developing its own assessments if those which are presented by Commission and Council do not meet your expectations, and also on the point of interinstitutional agreement? So Commissioner Reynders mentioned how important that is to have an interinstitutional approach to this matter. This was actually recommended by Parliament, and it was not implemented. Can you please unmute?
Yes, can you hear me now?
Yes.
Yes, indeed. In 2016, we had already had one report, and this interinstitutional agreement was not pursued. It is still what we prefer, because I think it is right to say that it doesn't make sense if every institution kind of cooks its own soup, as we would say in German. Because we need to reunite our powers. We are facing a very strong enemy here. The threats towards democracy are very severe, and we have come very far already. So, and the ones who want to weaken the European Union and who want to weaken the rule of law, they act in a very intelligent manner. We've seen that during the last weeks. So I think we should really reunite our forces. We are working on our plans there. We had a competence quarrels, unfortunately, within the Parliament first before we could start to work. But we really hope that we will have a dialogue between the Commission and the Parliament, and of course engaging also the Council, so that we can find a way to be in line. On the other hand, I find it extremely difficult because, of course, the Parliament is the place where the political parties come together, and this is something. A very unfortunate development, I would say. We've now seen that the EPP, some parties there and some individuals have spoken out loudly, but I don't want to personalize it too much, but I myself am a member of bodies where we should treat these questions and these problems. And we spend a 2 hours meeting on the situation we are facing at the moment, the measures we are facing at the moment, without except for one intervention by myself, mentioning what is happening in Hungary. And that is also for party political reasons. So, I mean, I'm here now as a vice president and not as a party politician. So, so I don't want to push on that too much. But of course, we need everyone involved in every institution to be clear on this. This is not, as Petra said, this is not a normal development within a crisis. This is a a constitutional threat to our European Union, and we really need every Democrat in every institution and outside to speak up now.
Thank you, Katarina. Yes, this is the dream scenario for any authoritarian, that's for sure. You were mentioning before the importance of privacy and data protection, which is another temptation that in the name of crisis to sacrifice our data protection standards and privacy. There have been these ideas to also, I think Commissioner Reynders mentioned, to tap directly in telecommunication companies. What do you think about this?
This is one of the big dangers of the actual situation. And we've seen in some member states already attempts to go very far concerning tracking of spotting people where they go, of exchanging and connecting data that is available from different sources, of making available data from health insurances or hospitals, for example, for government. These are very, very challenging and worrying developments. In my home country, in Germany, at the moment, we are developing an app which is voluntary, which enables you to, if needed, if you are infected, to trace who you met before on a voluntary basis. It is also very fragile. We really have to look at this very closely. But again, we need authorities who approve, who are able to check this, to approve this. So we have to set up the structures in, let's say, peacetime, in normal times, that we come back to them in times like these, because at the moment, I mean, we don't have really the European data protection bodies who are able to check all that is happening at the moment. We have to learn from that also for hopefully the next crisis that will not come, but to build up structures there too.
Yes, extremely important indeed. This point of highlighting the lack of a structural means for national data protection authorities to keep up with all these developments. Commissioner Reynders, also someone related to this topic, if you would like to comment as well, a participant raised in this context the role of independent prosecutorial authorities, because we are seeing some measures directed to direct access by national law enforcement to information held by IT companies and telecommunication companies. What is the role there of independent prosecutorial authorities?
Of course, it's possible sometimes to see the prosecutor playing a role in such a process, but for the moment, we try to explain the situation and to organize a European approach. Explain, we have the GDPR. It's worldwide a very efficient regulation to protect the personal data from the citizens. But also in the GDPR, there are some possibilities to use data in certain circumstances. I'm thinking about public interest and certainly about health and about pandemic. So what are we doing for the moment? We have sent, in collaboration with Thierry Breton, in charge for the evolution in the internal market, but also for the DG Connect in the Commission, so in charge of the communication, we have sent a recommendation to work together with all the member states about the development of apps. But we also send a guidance to the member states after consultation of the member state, but also with the national authorities in charge of the data protection and the European Data Protection Board. Because at the European level, we have a network of national authorities in charge of the protection and a board, and we will explain what is possible. If you have anonymized and aggregated data, it's possible to use to find against the pandemic, to send some information, to organize self-diagnose. There are many possibilities, and that is fine. It's also possible to develop some apps with the consent of the individuals. And I listened to the comment of Katarina about the possible apps in Germany. Of course, if you have the consent of the citizen to use an app and to send some information, why not? The problem and the limits are where we are discussing about some apps without the consent of the individuals and using in the tracking, to give an example, of personal data. And there, we try to see what are the limits and what are the possibilities, because of course, there are also limits in exceptional situations. It's not because we are in such a crisis that it's possible to do anything. And so the concern for the moment is to have a common approach at the European level, and we will organize that with all the national authority in charge of the data protection and the board at the European level. Of course, we will see if there are some deviations in one of those member states, and then said it's possible to have a reaction through the national data protection authorities, or maybe more than that with the law enforcement authorities, of course, if we are going too far. But it's the beginning of the process. You know that we have seen the development of many apps in other countries in the world to track some citizens about the crisis. And now there are many discussions in some member states about that. So we need to fix the limits and to try to do that together. Maybe one word just about the interinstitutional approach. I'm not against a real agreement about the three institutions, but you know that will take many times before to have a real legal agreement among the three institutions. So what we are doing now is to start a process about our annual report on the rule of law, and then to organize the discussions with the two other institutions, the Council and the Parliament. If after one or two reports, it's possible to put that in a more global vision and in a real interinstitutional agreement, why not? But I'm afraid to have years of discussions about a possible agreement before to do the job.
Thank you, Commissioner, for indeed, I mean, the privacy considerations extend not only to ethical challenges like potential discrimination and stigmatization, but also disowning people of their own data. And both of you and Katarina mentioned that the role of consent, that EU data protection law is actually a unique benchmark internationally, that we have such a robust framework that we all cherish.
Sergio, may I add just something? Because the consent, that already is kind of, you can say, yes, you have to give your consent, and then it's fine. But there have been discussions, for example, that you have a lockdown, you're not allowed to leave the house, but if you have this app on your mobile phone, then of course you're allowed to go outside. Now you can say that's voluntary, that's a consent that you give, but is that really voluntary? So this is really complicated, and I'm not sure if the European board is really I just want to put it there once, the best place for that, because alone from Germany, we have 16. Every state has its own data protection officer because it's a state competence. Maybe we could talk about that again.
Thank you. Petra, welcome back. Some of the participants, and also following up on our previous debate, are asking what concretely can be done in terms of, and what will be the value of this idea that you put forward of rule of law infringement proceedings. If you could develop a little bit on that. Can you unmute? Okay.
I'm sorry. Can you hear me now?
Yes, we can.
Wonderful. So I would like to repeat and stress what the Vice President said about the time frame. So I think it is crucial to realize after 10 years of rule of law backsliding in Hungary that time is on the side of those who want to dismantle the rule of law. So immediate action is absolutely crucial to tackle the problem. That's why when it came to our discussion about infringement procedures, I was emphasizing the prioritization, acceleration of the procedure, and also immediately ordering interim measures that can still put a hold to judicial capture, for example. Once it's happened, it's going to be very, very difficult to undo the harm that is happening. So in other words, later will be too late. And let us not forget, especially when it comes to criminal justice, mutual trust and mutual recognition of criminal judgments of the various countries. Here, individual rights are at stake. So there is a special emphasis and a special responsibility on the courts to put a hold to mutual recognition of judgments in case there is any doubt that someone doesn't get a fair trial by an independent judiciary in one of the member states. So I'm all in favor of debate, deliberation, and discussions. But in the end of the day, if the EU institutions do not act, it will be up to the courts. And if the Court of Justice doesn't move, then the national courts will suspend mutual recognition of judgments, because they have to comply with their own constitution and protect the individual rights of suspects and convicts. And let me emphasize that the independence of the judiciary is not only important for criminal justice, but it's equally important for an investment-friendly environment, for the Eurozone, for civil law, for the single market in general. So if the suspension of mutual recognition infiltrates into other fields of law and contracts will not be enforced throughout the European Union, this is the end of the principle of primacy. This is the end of the principle of direct effect, and so on and so forth. And I think coming back to the Commission's role is that it has a heightened responsibility to initiate cases against the member states that jeopardize judicial independence. Judicial independence is a very important segment of the rule of law, because ultimately it's the national courts, it's the EU court that interprets EU law, but it's the national courts that apply EU law. So if they are independent, this is again the end of European Union law. So in some infringement cases, especially vis-a-vis Poland, the Luxembourg court already took this into consideration. But we see a very interesting dialogue, I would say a toxic dialogue between the various courts at various levels. So for example, the Polish Prime Minister has just indicated that Polish authorities will not comply with ECJ decisions issued this morning until the Constitutional Tribunal, which we all know is a captured one, rules on whether the ECJ had jurisdiction to issue such a decision at all. So the question is whether the Commission will start an infringement procedure for the violation of the judicial independence of the Polish Constitutional Tribunal, which, by the way, it already established back then when the rule of law framework was coming to an end.
Thank you, Petra. On this point of the Polish Prime Minister, Commissioner Reynders, do you have any comment?
But I said there's an obligation to implement all the decisions of the Court of Justice. Until now, it was the case. We have had different positive decisions of the Court of Justice on the request of the Commission in the last months, and all the time there was a correct implementation in the member states. So again, I prefer to wait, because there are some clear commitment from the different member states, but there is also a clear decision from the court with some delay to explain the situation to the Commission. So we'll receive, I'm sure, the explanation coming from Poland, and I don't want to say too much about one of another comment from one other leader in one of the member states for the moment. We have taken all the decision to go to the court when there is a real risk for the independence of the judiciary, and we will continue to do that. I'm sure that is the most important. Anyway, it's the reason why it's the first chapter of our annual report. If you speak about the rule of law, that means I said that you have an union at the European level organized by law, and you need to have an independent justice to verify that it's possible to apply correctly the law by all, not by just the citizens or the authorities, by all. And it's true that it's not just for criminal justice. I said we have some investors having some problem to go to one of the other member states due to that. It's also the internal market, it's the civil law, it's in all. You need to have independent justice. So we'll continue to monitor and to work on it. Because at the end, to conclude, maybe if I may, because we are maybe sometimes constraints, I want to say that if you speak about a judge in Germany, in Belgium, in Poland, in Hungary, of course it's a judge at the national level, but it's a European judge. They are all European judges applying the European law. And so if we don't have the capacity to organize a system where it's needed for all the judges to apply the same way the European law, we don't have a real union. So it's a base of our organization without a correct implementation of the EU law by all the European judges. And European judges, I repeat, not only in the Court of Justice in Luxembourg, in all the tribunals, in all the courts in the entire Europe, we have European judges, and we need to protect those judges against any political intervention, and we need to protect them to be sure that they are independent. And again, we need also to train them, because it's better to have an independent judge who is also qualified.
Thank you very much, Commissioner, and thank you to all the panelists. I think we've all understood what is at stake. How deep and profound the consequences of what we are talking about are for the European Union in itself. At CEF, we will continue monitoring and participating in this reflection, not only like in events like the one of today, but also through our research. So yes, Commissioner, we will certainly contribute to this deliberation with our investigations. Next week, we will publish a new paper on the Hungarian government new law. So we will certainly have more inputs on this. Thank you to all. We need to close. We're a little bit behind, but it's been extremely interesting. Big thanks and courage to all.
Thank you. Bye-bye.
Thank you. Bye.